Okay, if everyone can please take their seats, we'll get started. All right, good evening everyone, welcome. My name is Rafi Kasabian. I'm the Vice Chairman of the Armenian National Committee of America Western Region, the ANCAWR. I'm also an attorney by profession and a First Amendment free speech lecturer with the UCLA Department of Communication. We're very excited to have all of you here this evening. On behalf of the ANCAWR, I would like to welcome everyone here today and those of us live streaming with us online for the 10th anniversary of the ANCA Grassroots Conference, which is being held in collaboration with the Promise Institute for Human Rights at the UCLA School of Law, my alma mater, the UCLA Promise Armenian Institute, and of course the CSUN Armenian Studies Department. The ANCAWR is the largest Armenian American grassroots advocacy organization in the U.S. with chapters throughout the western United States west of the Mississippi. The ANCAWR's objectives are threefold. Number one, to foster public awareness in support of a free, independent, and united Armenia and Artsakh. Number two, to influence and guide U.S. policy on matters of interest to the Armenian American community. And number three, to empower and represent the collective Armenian American voice on matters of public policy through political and community advocacy. As part of the ANCA's mission to educate, motivate, and activate, for the last 10 years, the organization has organized a content-rich, thought-provoking grassroots conference featuring speakers and panelists from around the world to discuss timely, pertinent, and relevant topics impacting the Armenian cause on a local, regional, national, and global level. We are especially proud to be hosting this evening's panel, which features leading international law experts, including our special guest for the evening, Armenia's Ombudsman, the human rights defender and recipient of the ANCAWR's Human Rights Champion Award, Dr. Arman Tatoyan. Kate McIntosh, the Executive Director with the UCLA Promise Institute for Human Rights. Kadni Kelkonyan, a seasoned international lawyer and litigator. And Rajika Shah, Director of the Loyola Genocide Justice Clinic. You'll hear more about our esteemed panelists shortly. Typically, our grassroots conference is held over the course of 3 days on a variety of different topics and issues. However, with the global pandemic that has impacted us all, we decided to hold one panel this year on a topic that is ever so timely and pertinent, and that we are all living through as we sit here today. Tonight's panel, titled Justice and Accountability After the Artsakh War, will examine the efforts to hold Turkey and Azerbaijan accountable under international law for their perpetration of grave human rights abuses and war crimes during the invasion of Artsakh last year and continuing into Armenia this year. Tonight's discussion will examine the ongoing proceedings at the International Court of Justice against Azerbaijan over its violation of the Convention on the Elimination of All Forms of Racial Discrimination, as well as other opportunities for accountability under international law, including Turkey and Azerbaijan's liability for the deployment of Syrian mercenaries and other war crimes. I would like to thank the CSUN Armenian Studies Department for hosting this forum tonight, as well as UCLA, the Promise Institute for Human Rights, the Promise Armenian Institute, as well as our esteemed panelists for participating this evening. Thank you. I would now like to invite Dr. Vahram Shemasian, Director of the CSUN Armenian Studies Program, to share his welcoming remarks. Thank you.
Pari Erego, good evening. on behalf of the Armenian Studies program here at Cal State University in Northridge, it is my distinct honor to welcome you to this campus for this very important function. I would like also to take this opportunity to greet you in the name of the 4,000 Armenian students and 150 faculty and staff that CSUN has. As such, our student body, Armenian student body, constitutes about 8 to 10% of the total student population of CSUN. What we do is we teach Armenian language, literature, culture, contemporary issues, the Armenian American child, changing roles of Armenian women, and several other courses. Our purpose is not just to convey information and knowledge, but also to make sure that identity is preserved, and not just preserved, but also strengthened, because without the preservation and strengthening of Armenian identity, I don't think the ANCA or any other advocacy group will be able to do much. If there are no Armenians left, no such organization will be able to perform well. Also, I would like to welcome Dr. Tatoyan to this campus. I think this is the first time that you're here, and it was very nice to meet you on several occasions. So I am ready to listen, I'm ready to learn, and I wish you an impactful and enjoyable evening. Vatskenit Gadar, Yev Sharunagenk. Shunagalim. Thank you.
Dear guests, it's my pleasure to be able to introduce our esteemed panelists for this evening. If you bear with me, I'd love to get a chance to introduce everyone here and their incredible experience in the field of international law. Of course, we have Dr. Arman Tatoyan, who earned his Masters of Law and PhD from Yerevan State University's Department of Criminal Procedure. He also holds a Master of Laws from the University of Pennsylvania's Law School. In 2016, Mr. Tatoyan was elected for a 6-year term as the Human Rights Defender of Armenia, also known as the Ombudsman of the Republic of Armenia. He's also served as an ad hoc judge on the European Court of Human Rights and international advisor of the Council of Europe's Directorate General of Human Rights and Rule of Law. He's an associate professor at Yerevan State University and the American University of Armenia. He's also previously served as Deputy Minister for Justice for Armenia between 2013 and 2016, and a Deputy Permanent Representative of the Government of Armenia before the European Courts of Human Rights in Strasbourg from 2013 to 2016. He was recently honored by the ANCA's, as the ANCAWR's Human Rights Champion for his service in upholding and defending the rights of the Armenian people. Thank you very much, Dr. Tatoyan, for your time today. Kate McIntosh has worked in the field of human rights, international criminal justice, and protection of civilians for over 2 decades, and is currently the executive director of the UCLA Law School's Promise Institute for Human Rights, who we are very proud to have as a co-host for tonight's event. McIntosh has held multiple roles at international criminal tribunals, including the International Criminal Tribunal for the former Yugoslavia, and has been part of post-conflict human rights field operations in Bosnia and Rwanda, working to rebuild the justice system after genocide. For 8 years, Kate also worked with Doctors Without Borders, providing legal and policy advice to operations in over 30 countries around the world, and leading advocacy in support of some of the world's most vulnerable populations. Rajika Shah is the Deputy Director of the Center for the Study of Law at the Genocide Loyola Law School, where she also runs the Genocide Justice Clinic. Prior to joining Loyola, Shah litigated international human rights and property restitution cases on behalf of Armenian and Sudanese genocide victims, indigenous groups, and religious and ethnic minorities. She has represented plaintiffs in numerous complex high-stakes disputes against foreign sovereigns and commercial entities at both the trial and appellate levels. She also represented Libyan terrorist hijacking victims before the U.S. Foreign Claims Settlement Commission. And finally, our moderator, facilitator of this conversation, and esteemed panelist, Karnik Kerkonyan, a seasoned international law expert and experienced litigator. He holds an AB magna cum laude at the in government from Harvard University with 2 law degrees, a JD from the University of Chicago, where he served as a law review, as well as a postdoctoral diploma in public international law from Cambridge University, where he studied under James Crawford, later a judge at the International Court of Justice. Tatoyan represents regularly on matters of public international law at the International Court of Justice, the European Court of Human Rights, and the application of international law in U.S. courts. He's also currently an adjunct professor of public international law at Artsakh State University. I'd like to thank, again, all of our esteemed panelists for joining us today, and we'll turn to the conversation. Thank you all.
Thank you very much, the ANCA Western Region, for putting this timely panel, and of course CSUN for hosting us here today, and the Promise Institutes at UC as well. And of course, they have a wealth of knowledge on international law and the topic justice and accountability after the Artsakh. It's a very timely piece, and it is one that I hope that we are going to dig into deeply. This is a knowledgeable audience, so the goal here really is some insights. The purpose of this discussion, I hope, is going to be insightfulness and tangibility. I think realities and not imaginations, the tangible, and hopefully we leave today with an understanding and with some direction on what must be done. And I'm going to get us started, of course, and then we're going to open up answers. And what I don't cover, I am sure that let's just not waste any time and jump right in. Turn to Dr. Tatoyan and ask if you can give us just an overview on the ground today. Azerbaijan's recent assault on Armenia. Additional.
Thank you. It is a privilege and honor for me to be here with you today among so many professionals and dedicated people. And I want to express my thankfulness and gratitude to ANCA Western Region for inviting me to this and for bringing us together and for this very important event on accountability. Unfortunately, after the situation, both in Armenia and Artsakh, and we experienced violations, war crimes every day. Recent escalation was on when Azerbaijani forces started invasion, another invasion of the sovereign territory, and November already military attacks. I dispatched finding mission Sunik province. We received from civilians. Received that they hear shellings of artillery and different kinds. And I have to say that these attacks themselves were very dangerous because they were in the immediate vicinity of our villages, causing direct threat to the civilian population, to the direct threat to life of people, and to health, to their peace and security. After the war, but I have to say that this situation continued. This situation has an ongoing context. So, as you may know, from May 2021, Azerbaijani military forces there was in 3 cases there were incursions inside the territory of Armenia, in Sunik, Gegarkunik, and some other parts of Sunik in the Kaban community. Every day since that incursion, and also appearance of Azerbaijani military armed forces or armed servicemen in the vicinity of our villages, on the roads between the communities of Sunik, we experience every day shootings, almost every day shootings, stealing cattle, attacking civilian communities. Even these violations very recently got extremistic and massive amounts, such as setting fires near the villages, for instance in Gegarkunik, near village Kut, Azerbaijani armed forces for days were setting fires to on pastures, and civilians were deprived of the possibilities even to earn their income for their families. So having said all of this, let me say that apparently their presence in the villages, near the villages and on the roads causes huge tension, and itself it is already violation of the rights of people, because due to these shootings, illegal other activities, stealing cattle, etc., the normal life of people is just, I can say, disrupted.
You know, I'm going to switch to using first names here because I think we have an audience that understands a lot of the background here, and I think we should get into some of the substantive issues that Arman's comments now really raise. And Kate, I want to go to you, and I want to ask you, isn't what we're seeing right now in the aftermath of the Artsakh war and the recent aggressions through the summer and into now over Armenia's sovereign territory, aren't we seeing appeasement in the making in terms of other international actors not stepping up and not realizing where this actually leads? And I want to not necessarily start with a geopolitical question, but really a question of international law. Where does the war of aggression begin? Where does it end? At what point do encroachments on sovereign territory trigger obligations of international players? And why do you think it hasn't happened here?
I think this is on, yes it is. Well, maybe to answer the legal question at least first, which is a bit more simple. I mean, as I'm sure everyone is aware, one of the most fundamental principles of international law since the end of the Second World War and the founding of the United Nations is the prohibition on the use of force by one state against another. So that's enshrined in the United Nations Charter. It's an absolute fundamental prohibition. And the use of force has been defined in many ways, but essentially, obviously, the kind of aggressive action that we've seen on the part of Azerbaijan against Armenia would fall into that characterization. So it's one of the fundamental rules of international justice. I mean, that's why we have an International Court of Justice, because disputes between states after the Second World War were supposed to be regulated in the International Court in order that there would be no more wars. Right? So that's how it's supposed to work in theory. So any incursion or aggression against the territory of another sovereign state is a fundamental violation of international law. Now, what can be done about it? Legally, any dispute between states, any violation of international law can, in theory, be taken to the International Court of Justice. However, there are often problems of jurisdiction. States may or may not have accepted the jurisdiction of the International Court of Justice. The case that we'll go on to hear about in more detail under the Convention for the Elimination of All Forms of Racial Discrimination is one in which Azerbaijan and Armenia have accepted the jurisdiction of the court for that particular treaty, so it provides an opportunity to have that grievance held. But in the case of aggression, it's not so simple. As well as it being a violation of international law, of course, there's also the crime, the international crime of aggression, which is something which has been more recently incorporated into the statute of the International Criminal Court, but exists in customary international law and was prosecuted after the Second World War, of course, the crime of aggression. So while the International Criminal Court is not an available forum in this case, because neither Armenia nor Azerbaijan are states parties to the Rome Statute of the International Criminal Court, that crime of aggression, again, does exist in customary international law, but again, we're back to the problem of forum. Where would that be tried? There is no relevant international criminal jurisdiction in which individuals, and in this case it would be state leaders, could be prosecuted for that crime. So it's a slightly paradoxical situation in which we're talking about one of the most fundamental principles of international law, and yet the available legal remedies are actually fairly weak.
And, reading Arman's reports that focus on a lot of the underlying factual scenarios that lead to, let's say, violations under the convention, CERT, for example, as well as potentially other violations of international law, humanitarian law. we keep coming back to really kind of serious atrocities, and we're going to get into the treatment of those atrocities under international law a little bit later. But I wanted to ask you, Rajika, how fundamental is the documentation of such crimes, of these incidents? How fundamentally important is it to develop a substantive factual record for international tribunals, for the prosecution of, I'll speak loudly, for the prosecution of international crimes, as well as for actions that are, yeah, the microphone doesn't work. There we go. How important are the fact-finding missions, the underlying factual work that's taking place to investigate the atrocities? How important is that in the evidentiary proceedings that take place in terms of the prosecution of war crimes?
Is this on? Yes? Okay. Thank you. So that's a great question. So the evidentiary record is, of course, crucial to develop for any number of reasons. But so the work that Mr. Tatoyan's office is doing, the work that the Artsakh human rights defender is doing, this work is absolutely critical, and the work that other NGOs are doing to flesh out the facts and develop what actually has happened, because that information can form the backbone of any potential eventual prosecution or any attempt to, make some determination as to where accountability lies and who the potential perpetrators might be. So as lawyers, we always think about what are the requirements for admissibility of evidence. Probably many of you are lawyers, and so you are already familiar with some of the things that we have to consider. Has the evidence been authenticated? Is there a continuous chain of custody so that video evidence, for example, or photographic evidence, can we determine where it came from and what hands it has passed through before it came to the fact finder, so that we can ensure that it's authentic and is what it purports to be? Do we have firsthand accounts? That's, of course, always crucial. Here in the United States, we have rules against hearsay. International tribunals are a little bit more open with respect to the kinds of evidence that can be admitted, because the fact finder is a judge rather than a jury. But so development of the factual record, getting a full, impartial, independent investigation of all of the facts that happen on all sides is absolutely crucial, and now is the time to be doing it, talking to people, getting their firsthand accounts, so that that evidence is there in the event of some eventual prosecution or other type of accountability mechanism.
And really, I think if we can kind of step back now to September 27th and understanding that we have basically a continuation of not just necessarily a geopolitical change, but also the same types of human rights violations that we saw in the war, now continuing. I think that there's one aspect that most Armenians find very frustrating, and that is the work of, let's say, international human rights organizations in their approach to the war in terms of human rights violations and the protection of civilians in this particular case. And what we've seen is really obfuscation, distortion. We've seen mirroring propaganda from Azerbaijan with respect to atrocities, as Rajika was talking about, in terms of the circulation of videos and authentication of documents. Both the ombudsman in Armenia and the ombudsman in Artsakh have done a tremendous job in compiling that information, authenticating that information. And I guess my question comes down to this. Despite the evidence that has been prepared, circulated, the reports circulated to international human rights organizations, what is it that causes the international human rights organizations to insist on on conduct of parity, of equivalencies, when it is clear from the documentary evidence as to which side the aggressor was, what the atrocities were, who committed them, and when. What is it, Kate, that we're missing? What is it about the unique structure, perhaps, or the mandates of these international human rights organizations that are struggling with this? Why do we sense that struggling? And what can you do? What can you say to help us kind of understand and enlighten us as to what the real kind of power mechanisms are that are at play?
Sure, well, I can try. I can't really speak on behalf of those organisations, but I think, first of all, I think it's important, or maybe it's not important actually. I think perhaps one source of the problem and a relevant issue is the separation of the aggression from the conduct of the hostilities. So legally, those are two different questions. So I don't think anybody disputes that Azerbaijan was the aggressor. I don't think any human rights organisations do. They may have done at the beginning. I think that wasn't completely clear to people who were further away, who might have been reluctant to pronounce, but now I'm fairly sure that that's taken as understood, right? Under international law, the question, so this issue of aggression that I was talking about just earlier is, that's illegal. That's a massive violation of international law, and it clearly, Azerbaijan is the one who's violated international law. It's a different body of law that regulates the conduct of hostilities and how the parties act once they're during the war. And I think this division, that's a legal division, and I think that will guide the way the war is interpreted by human rights organisations. So they can pronounce on the aggression, but then they're looking at violations that both sides, who's committing violations. And I mean, both sides, as Armenia did also commit some violations, and for a human rights organisation, they would probably want to be careful to report those. The problem is, of course, in the wider framing. I mean, there are two things. First of all, there's the scale of the violations, and which side, the fact that both sides committed violations does not mean that both sides behaved equally during any conflict. And then there's the framing, right? There's the contextual understanding of what's happening, and I think that is the thing where the communities affected really struggle with this apparent sort of neutrality and the ticking of boxes about, when violations occur without putting it into that context. And just to reflect, it reminds me very much of conversations around the conflict in the former Yugoslavia, which I was more closely involved with, when essentially, and the Bosnian Muslims definitely committed war crimes, and the tribunal has found that, but essentially it was the two larger communities of the Bosnian Croats and the Bosnian Serbs who, along with Croatia and Serbia, decided they wanted to carve up Bosnia and keep half each, and the Muslims, they could get rid of them, and then for the Bosnian Muslims to see themselves being dealt with at the International Tribunal, for example, apparently on the same level as the other two, what they saw as aggressors, I think is very resonant with the kind of situation that you're describing now.
Yeah, I think that the idea of that mirroring is going to come up when we discuss the CERT case at the ICJ as well. But there's actual real consequences, right? There's human consequences to not calling out what it is. And I want Arman, if you would, to really to speak about what the consequences are of, at least in your experience in this particular issue, of international human rights organizations, perhaps hesitancy or the dedication to parity, or as Kate was saying, the idea of packaging scale in some sort of parallel world, when in fact the factual matters on the ground tell a whole different story. What are the actual human rights and human consequences of the hesitancy or the parity that we get from international human rights organizations on this issue?
Yes, thank you, Garvin-Jan. Let me first say that, unfortunately, during this war, before that and after the war, international human rights organizations stayed just silent. The reaction was very disproportionate. When you open a website of the United Nations organization, there is a very nice expression. No one should be left aside, no human right ignored. No human right ignored. We were reporting literally from the scenes of violence. And the international community was silent, by the way, by this downgrading the human rights system. As you very rightly mentioned, since World War II, the world agreed to decide all the things peacefully within international proceedings, but international community, by this silence itself, downgraded the whole system of human rights and the whole protection system that it has been developing since the Second World War. Azerbaijan has been always isolating Artsakh from the outside world, doing everything to isolate Artsakh. We were calling, my colleague in Artsakh, all of us, we were calling on international organizations, human rights organizations, to visit Artsakh, at least to pay one visit. This is a pure human rights issue, right? There is a status neutral, very famous concept which delivers that political status of any territory that should not affect human rights protection. Because in Artsakh, we have civilian population, women, children, persons with disabilities. What is the relation of these people with politics? Of course, no relation. But why they do this? Why they keep silence? Because politics, there is a huge influence of politics. And I think that human rights organizations, unfortunately, allowed politics or the politicians to influence human rights and to politicize human rights generally, humanitarian consequences even. And as a result, what we have, more and more violations, severe and severe. And the problem is that this genocidal policy, we have to, first of all, to understand what is the real cause, what is the real source. The real source is the policy. And the policy continues. Since there is an impunity, the international organizations are silent, or at least the minimum is there is equivalence. Well, I have to say, for the sake of, let's say, of fairness, that there were certain, of course, reactions from international organizations. But in general, of course, it was disproportionate. And what we see? We see that the Azerbaijani authorities, Turkish authorities, they see that there is impunity, there is no reaction coming. Of course, they expand their violations, the incursions, and moreover, they try to manipulate with the international human rights organizations, doing everything to falsify the situation on the ground. That is why I think human rights organizations themselves, by these activities, by their passiveness, they are becoming victims of their passiveness, because they are betraying what they have been advocating for so many years. And I think this is the main issue, that the consequences are getting more and more severe and deeper, which we can observe on the ground every day. We are reporting, as you very rightly mentioned, about the videos, about the evidence, right? That hearsay is not allowed, etc. Yes, I agree with you. But we were documenting from the scenes of crime, from the attacks, from the scenes where attacks were taking place, and there was silence. This is the issue. And even sometimes I was feeling that some international organizations are waiting, they're kind of waiting for some other reports from the other side in order to keep the equivalence. But human rights protection requires immediate reaction, which should be preventive. Unfortunately, this reaction was very passive, and again, this resulted even in a dangerous public discourse that human rights and democracy contradict security, though this is a different topic. But these are globally more dangerous consequences even for the state of democracy generally.
Rashid, I want to get to you, and I know that you want to say something, but I also want to overlay it with something else. And isn't it really an indictment of the system in terms of international human rights law, international humanitarian law, an indictment of a system where reaction is so slow, or that there's a waiting period for silence for whatever geopolitical events to transpire? Shouldn't the issue of human rights be on a level? I mean, clearly I'm asking a normative question. Should it? Why isn't it? What is it that you, and dealing with the specific patterns of conduct that we're seeing, and I'm going to ask you to tell me, these aren't unique, the precursors to ethnic cleansing, cultural appropriation and destruction, these all tell the same story, and they all lead to the same thing, theoretically, right? I mean, if you look at cultural destruction and appropriation, you look at the types of hate speech and provocation and patterns of conduct, aren't these the precursors to genocide? Aren't these the elements that suggest genocidal intent at some level? And what are your thoughts on what Arman said regarding the fact that where a system is silent, they're essentially creating more significant humanitarian crises?
Yeah, so there's a lot there. No, that's okay. I have a lot to say. I'll try to keep it as short as I can. So I think here, to me, more than anything, this conversation now, I don't see how we can get away from the discussion about law and politics. And international law, yes, of course, it is law. It's very strong law, and states. I'm unlike many people who are trained in international relations. I'm trained in international law, so I really believe in the international legal system, and I believe that it has made tremendous impact, particularly since World War II. But it is also the case that I think more so than domestically, the role of politics can't be ignored when it comes to international law and the role of international relations. And I think this is what we see playing out in all of the discussion that we're now having. So when Mr. Tatoyan is talking about, and when you're talking about, why are human rights organizations, sort of why are they struggling for parity? Why don't we hear more? Why is there a delay? Why is this taking so long? To me, I see a couple of things going on. One is, of course, as a lawyer myself and as a litigator, lawyers are not risk takers. Lawyers are sort of infamously known for being not risk takers. And I think a lot of that comes from the way that law is practiced, which is we are trained to look at facts, to analyze facts, to carefully apply those facts to law, and to present all of those facts to a neutral arbiter, a judge or a jury, some kind of neutral fact finder who then looks at everything from this, supposedly neutral standpoint, looks at the arguments of the one side, looks at the arguments of the other side, and reaches a decision. And so my sort of lawyerly instinct is to not want to reach any kind of conclusion when it comes to a conclusion on the law. Even though we can all see what kind of facts there are on the ground, there's a reluctance, I think, to reach any sort of legal conclusion until there's been a process like that. So I think that's one aspect of it. But the other aspect is the politics and the fact that, so to have a system like that, a mechanism like that, that takes time, right? I mean, we're still in the process of collecting facts, much less having some kind of forum to put those facts to adjudicate them. But in the meantime, 1 year has passed, and more time will continue to pass, and so there is this sense of frustration that I can well understand. Something that Kate perhaps very carefully didn't mention when she was talking about aggression is the role of the Security Council, which plays, the UN Security Council has a central role in the international legal framework for dealing with acts of aggression, unlawful use of force, threats to the international peace and security. Well, as we know, the Security Council is a political body. It's not a legal body. And of course, there are 5 permanent members on the Security Council: the US, the UK, France, China, and Russia. And those 5 members have a veto. And they can veto any resolution that comes before the Security Council on an issue that they just don't want the Security Council to pronounce upon. And so the political issues are there at the heart of dealing with also these complicated legal issues. So that's maybe a start.
No, and I think it's a good one. It's actually a really good segue to talk for a moment about the ICJ case that's pending presently. As Kate, you mentioned, it involves the Convention on the Elimination of All Forms of Racial Discrimination, and I want to talk a little bit about the claims that are part of that case. But in doing so, and given the wealth of information that went into the case, and if anybody were to see the applications, there are significant amount of factual material was tendered to the court in the actual applications, and many of the resources involve fact-finding missions and things of that nature. And Arman's reports, the reports of his office, were a fundamental part of that. And I wanted to ask Arman to speak a little bit about the relationship of some of the claims in the CERT case that's pending in the ICJ, in particular the idea of cultural destruction and appropriation, hate speech, and of course the claims involving POWs and the military trophy park. If you can kind of explain and tie that together as to why these claims are the ones that are presented here, other than the jurisdictional component. What is the value of these claims? What is the value of these claims in terms of the resolution of or bringing to justice the perpetrators of the crimes that we were just speaking of?
Thank you, Garlic John. But before turning to that very specific issue, I just wanted to reflect on what was said on the role of politics. You know, the role of human rights and human rights organizations is to neutralize politics, not to allow politics to influence that much human rights, because there are two kinds of organizations, right? Court organizations or judicial instances and quasi-judicial instances. And I think that we are now referring to human rights organizations that are non-judicial, but those activities of these organizations are crucial for courts. And that is why these organizations are fast, they are quick, and their purpose is to react immediately in order to prevent violations. People were dying every day and every moment. These organizations were collecting evidence, were comparing, etc. No, of course, I think that this was the influence of politics. They were not able, unfortunately, to neutralize politics because despite the fact that they have all the guarantees, they're most protected organizations within international community. That is why I think that we have also to look into the ground to see the real consequences. But I agree, of course, on the court proceedings clause that was mentioned just. Now turning to Garnijan, to the question that you raised when it comes to ICJ and generally court proceedings. Well, as you rightly mentioned, Azerbaijan currently is illegally keeping prisoners of war, and even as a result of recent escalation of November 16, we have more prisoners of war. Now we're working with the Red Cross to see what is the exact number. And the issue of cultural heritage and the trophy park. Well, all those claims and all of these points, they're connected with the genocidal policy that is being carried out by the Azerbaijani authorities. Keeping prisoners of war, yes, they keep them. They use them for bargaining purposes to gain political and military benefits, artificially launching proceedings, but the purpose is to cause as much suffering as possible to the Armenian society, to the families of these people, and also these people are in prisons of Azerbaijan under threats to their lives and ill treatment. When it comes to cultural issues, this is also a part of genocidal policy. The destruction of, immediately after the war, Armenian churches, Armenian cultural heritage, they're being destroyed. And another huge problem here is that the belonging is now being challenged by the Azerbaijani authorities, illegally challenged, because the claim is that the authorities, the policy is that these churches belong to to Albanians, to some other nations. And this is also something that relates to the distortion of facts and generally genocidal policy in the Drupi part. This is something that is proof of a policy, state-sponsored policy of hatred and animosity towards Armenians. Children above 6 years old have easy access to this trophy park, which was, even before the claim, Armenia's claim to ICJ, it was, there were mannequins, wax figures of Armenian soldiers, of prisoners of war, and we documented the words of designers of these mannequins who said that they received instructions to make these mannequins as ugly as possible, apparently for creation, for hatred, incitement purposes. I think these claims should be seen as part of this one chain or circle to prevent the genocidal policy of the Azerbaijani authorities, but most importantly, to recognize, to reach the fact that this court, this high court, recognizes that these are the chains of this policy, and that is why the provisional measures, I think, would be very important in the sense of prevention of this kind of policies that amount to genocidal policy.
And Kate, what do you say to that? And in particular, many in the audience are probably watching saying, okay, so what? What does it mean? What does a favorable judgment, particularly in terms of interim measures, and perhaps on the merits as well, what does it mean in terms of, particularly in the substantive case here where we're dealing with CERT, what does that mean? What does that cause, both in terms of on the state actors and in terms of potentially deterrence and other results, remedies, if you will, globally? How important is the case, and what are your views on what the value of a favorable judgment could be?
So that's a very interesting question because, of course, it's a consensus-based system, right, that the International Court of Justice could pronounce if it finds in favour, or if it finds that Azerbaijan has violated its obligations under the convention, it can provide for reparations, for Azerbaijan to pay reparations. Will Azerbaijan pay reparations? Well, that would remain to be seen, and of course the International Court of Justice doesn't have any enforcement powers. But one thing that we can say is that states do seem to mind about these things. I mean, Azerbaijan has certainly reacted to the complaint. In fact, I think a couple of days later filed its own complaint back, which was mainly focused on landmines. I mean, there wasn't a lot of detail, but it was. So, and Azerbaijan is, of course, defending the case. And I think that tells us that this matters to Azerbaijan, perhaps to its international standing. It's not the only country that responds. I mean, in general, countries take the International Court of Justice seriously. I mean, the United States, which has not complied with some judgments against it at the International Court of Justice, nonetheless certainly did its best to avoid judgments against it. And I'm thinking, for example, of the famous Nicaragua case back in the 80s. So I think these international court judgments, so a judgment from an International Court of Justice operates in a slightly different way, perhaps, to the judgment of a domestic court, which can enforce its judgments and make sure whatever the court orders happens. But they are seen as very relevant to international status. So I do think it's very significant. I think it's a very smart move of Armenia to flag this. I really take your point, and I think the point that you've both been making, that the important thing is to get international recognition of what you are interpreting, or to understand this interpretation of something that might be some kind of precursor to genocide. And the International Court of Justice is a really excellent forum to get very serious world attention to those claims. So I think it is a very worthwhile endeavour.
And if we could take kind of a step back theoretically, Rashika, from this, and Arman mentioned the point of isolation, and that has many different dimensions, right? One is the fact that international human rights organizations during the war would not go to see what was happening. The other is the fact that Azerbaijan has interfered with the ability of organizations such as UNESCO, in the case of cultural heritage protection, to go and see what is happening. I wanted to ask you theoretically, concept or the conduct of isolation. What is the role of isolation? Does it have a role in cases of genocide, generally, as a precursor, as an element, not necessarily an element of the crime of genocide, but in terms of kind of a historical context? Does isolation play a role? What is that role? And have you seen it before in other instances where there's been isolation of a population or isolation of issues and that have not been allowed to get into the public forum, or that perspective has not been able to get into the public forum? Perhaps it's kind of a loaded question, I understand that, and I apologize for that, but there is a role here, right? That isolation means something. Why is it being done? Why does that isolation, why is that a state policy? And do you see it feeding into perhaps more significant circumstances, such as war crimes and other violations of international human rights law?
So that's a really interesting way of framing the question. I'm not sure that I've thought about it in quite that way. So I think, you know, my immediate reaction is on a couple of levels. One is, I suppose, again, on the, you know, the kind of political, geopolitical, you know, strategic level. And I am not an expert in those kinds of things. I can't really speak to that. Thinking in terms of, you know, maybe potentially some legal precedent, I guess the closest thing, or the first thing that comes to mind, is the situation in Cambodia, which there has been a tribunal, a hybrid tribunal operating in Cambodia over the last 15, 20 years or so to prosecute serious atrocity crimes that occurred during the Khmer Rouge in the late 70s. And I guess the couple of the things that bring this instance to mind are, one, the fact that there has been so much time that elapsed since the crimes occurred until they are being prosecuted. And I think I see elements of what you're calling isolation in that. You know, I think there was the politics, the domestic politics in Cambodia were such that I think there were attempts to just turn away from what had happened and really not want to face them, and certainly not want to bring accountability. And it really wasn't until the late 1990s, when there was a change in the government, that the Cambodian government really said, okay, you know, we want to do something about this. But I think also about isolation at the time in the 1970s. And, you know, how compared with today, I would say, you know, there's a big difference today than there was back then, which is back then there really was a reliance on, you know, international news reporters, journalists, people on the ground who could bring information to the rest of the world, without which nobody really would know what was happening outside of the people there on the ground. Today, though, I think we are in a little bit of a different situation because of social media. Of course, it can be used in negative ways, but it can also be used in positive ways, and the internet. And, you know, it is possible to bring light to situations now in a way that it has not been before. So, you know, again, if Azerbaijan is preventing international monitors or international NGOs, human rights NGOs, from coming into the country, you know, in order so that they can't collect this kind of information, that obviously is not a good thing, and is maybe contributing to some destruction of evidence. But I also think that individual citizens are empowered to speak out in a way that they haven't been before. So that may be a way to counteract a little bit of that isolation.
And I think that Arman and I have discussed a concept, and I want to get people's thoughts on this as well, and that is the ability or the need to look at the war and its aftermath and current situation as well in a historical continuum. I think that there's a lack of appreciation that perhaps is not voiced properly or not voiced enough. That there's a bigger story here. And I'm not even, well, I'm not going to put words in Arman's mouth. I'm going to ask him, what is that historical continuum? Is there a historical continuum? And if it is, what are those parameters? And what do you feel in terms of the international community not, are there aspects of the story that are not being communicated or they're not being heard?
Thank you. Yes, this is a very important question. In the reality, the current policies of the Azerbaijani authorities are deeply rooted in the policy, genocidal policy that was being carried out by Turkey during the Armenian genocide and after it. There is evidence clearly showing this. I can just bring two or three examples to show. Immediately after the Armenian genocide, one of the perpetrators and organizers well known is Enver Pasha. His brother Nuri Pasha, who was heading the army, Islamic army, went to Baku, then organized and perpetrated pogroms and massacres in Baku of Armenians. And this was again the chain of the same policy. And I have to say that on December 10, after the war, in Baku, there was a military event dedicated to the glorification of the results of the war. The Turkish president went there and he delivered a speech. He said that he compared victims, the soldiers of the Azerbaijani army with the souls of those who were organizers of the Armenian genocide, and mentioning there by names Islamic Army, Enver Pasha, etc. So by this, there's a clear rhetoric, and not just the rhetoric, but the real policy of the genocidal intent is there. And we observe this at my office. We have specialists specialists who are who are gathering evidence. They are specialists of Azerbaijani language. We are monitoring very closely what is happening, and I can say that the intent is the same, which has the same components: extermination of people, destruction of civilian communities, destruction of property, destruction of cultural heritage, religious heritage, etc. And more. So this is I think that the history of persecutions, etc. And when we discuss them, when we monitor them very closely, all these things are even identical. The policies, even the rhetorics, and even the rhetorics of the Azerbaijani authorities target the same issues. In the recent statements, for example, related to the Armenian diaspora, naming Armenian diaspora as a poisonous community who is poisoning Armenians, claims that these are the same people that form the part of the nation of Armenia. So there's a clear historical link, and even we can easily claim that we deal with literally the same policy, it just with slight changes in terms of time and maybe in terms of, as was mentioned, some new modern technologies. But itself, the policy is the same.
And Kate and Roshika, I want to kind of jump off that, use that as a springboard to the next question, because there is, in the eyes of Armenians, a larger story here, right? There's this centuries, let's say, centuries old thematic precursor to what literally just happened. And in that, there are issues of restitution, the issues of recognition seem to echo. What is the value of recognition and restitution in terms of a deterrent? And And should, let me back up and say, I know this is probably something Rajika, let me go to Rajika first on this, because this is something you've worked on extensively. What is the forward-looking benefits of recognition and restitution?
Right, thank you. So that's a great question. Recognition, restitution, reparations, these are all, there's a fundamental right to a reparation for victims of serious gross violations of international human rights law and humanitarian law. And for any number of reasons, this is crucial in a forward-looking way, certainly. In an immediate sense, I think certainly having worked on property restitution cases for many, many years, we saw certainly with the Armenian genocide 100 years ago, one of the first things that happens in a genocide or in a situation of mass atrocities is people have to flee their homes, often with very little to no notice, and they have to leave behind all of their belongings just at the time when they need to have some sense of security and stability. And so in a kind of immediate way, restitution can help to restore some of the tangible things that were lost. But I think much more importantly and much more, symbolically is what reparations and compensation represents and the value that it can have in restoring a sense of justice, really, and wholeness to a community that has been torn apart, and the role that it plays in facilitating transitional justice, really moving a post-conflict society and community away from the immediate conflict to a place where the community can start to imagine something more stable and start to think about healing. That takes a really long time, and there are a number of components to it, but reparations is really a key part of transitional justice.
Kate, if you could kind of jump off of that and talk to me a little bit about your experiences in Bosnia and Rwanda on a very specific issue that dovetails really well here. And that is something that Arman has worked on, and that's the issue of indoctrination, of hate speech, and the institutionalization of things such as hate crimes or the glorification of perpetrators of hate crimes within a society, and the role that played perhaps in what we saw in the former Yugoslavia, what perhaps you saw in Rwanda. What is that tie? Because this is something that Arman has focused on significantly, actually since before the 2016 4-Day War. There was a report that he had authored with the Human Rights Ombudsman in Artsakh at the time, Rupa Medikian, regarding the hate speech. And really, during the CSUN case, I have to say that was one of the most dramatic moments in Armenia's case in chief, was the demonstration of the actual rhetoric coming out from the president of Azerbaijan. These weren't, local civilians. This is the head of state. What is the role of that? Why is it such a focus of, let's say, human rights institutions? And what role does it play what role has it played in the former Yugoslavia and Rwanda? What have you seen?
Yeah, thanks. And I should say that I'm sure Rajika also, with her scholarly work on genocide, would have something to say about this too. But I mean, for sure, particularly in the case of Rwanda, which was a pretty straightforward genocide situation, the dehumanization of the group was very marked and an essential part, and I think it's generally understood to be a part of genocides generally. So the dehumanization in Rwanda, the term used was cockroach. And sometimes it's a term which you don't necessarily understand from the outside how loaded it is. But, within that culture, it's something which is really suggesting that these are not people, right? These are not people, and in fact, there's something bad and dirty, and actually that moves towards we need to eliminate them. So that was prosecuted specifically in Rwanda in the tribunal. Famously, it was the media trial. So it was the radio that was then in the mid-90s in Rwanda was the means for disseminating this information. I think the parallel today would probably be social media. And of course we saw also in Myanmar, around the Rohingya, the kind of hate speech that was circulating on Facebook that was thought to have incited violence against that community. So I think that it's an absolutely crucial ingredient. And as I said, it was identified and prosecuted in the genocide trials in Rwanda. Now, Rwanda had a somewhat easier journey out of that terrible experience. I mean, easy is not the word, but I mean, in Rwanda, the situation, of course, was that the persecuted group actually were the ones who stopped the genocide, right? It was the Tutsi community who'd been living in exile who essentially invaded and put an end to the genocide in the face of inaction from the international community, and are still now in power. Right, so Paul Kagame is still in power. That's brought its own problems. But in terms of shifting the consciousness, I think it's been relatively easy for Rwanda because the persecuted group is in charge. So Rwanda has done a great job of memorializing the genocide and, having sites and moving towards this kind of transitional justice that Rojika was talking about. For Yugoslavia, it was a completely different problem. And there was much more the issue which you flagged of the perpetrators being idealised, the perpetrators of the mass crimes, including genocide in some cases, were still popular. We still had nationalist governments in charge, and some of these individuals were still popular and still had a following. And the only reason any of them got to trial in The Hague was really, the hard work of the chief prosecutor, but leveraging political discussions and deals that were going on at the time, and in particular discussions around accession to the European Union. So both Croatia and Serbia are very keen to accede to the European Union, and the prosecutor of the Yugoslavia Tribunal managed to get surrendering the indicted war criminals to the tribunal to be a plank part of that deal. So, that's the kind of level of geopolitical influence that was needed to make some of those trials realities, because back home, these people had political constituencies, but the people in charge at the time were able to, offer their communities the prospect of a much brighter economic future as a price to pay for handing over people who've been indicted by the tribunal. But I think that different story and that different trajectory has meant that the hate speech has actually not died out in the former Yugoslavia, and the situation in Bosnia at least, because the other countries are more stable, is actually pretty worrying and precarious even today.
And Arman, if I may, just drawing on the examples that Kate just highlighted, I sense that there were, in both examples, that there are similarities in the present circumstances in terms of the post-Artsakh war, and if you could kind of elaborate on that. Basically, what Kate was talking about in terms of the glorification aspect that we saw that she was speaking about in Yugoslavia, as well as the indoctrination, the hate speech that was used in Rwanda at that time with radio, and here we have with social media. What do you see in terms of the reality on the ground, even today?
Well, after the war, I have to say, evidence clearly shows that after the war, hate speech, institutional hate speech, and encouraging Armenophobia has deepened, and it got extremistic even forms. This is because of impunity, because this is because of improper reaction, of course, and the preventive mechanisms are not effective. but these examples are numerous that confirm this institutional policy of hatred. Well, first of all, this is glorification of murderers, of Armenians, of perpetrators at the highest level, state level, which comes already, it has a history of so many years. Another very important example is the education system in schools, secondary schools. All of the examples even are built on Armenophobia, and children are being raised with these feelings. Another important thing is that at the very state level, at the highest state level, it was announced many times, that the falsification of history, and many times was announced already, or the president of Azerbaijan in his speeches after the war was exactly targeting Armenians, not Armenian authorities, not military, but Armenians, every Armenian, and it is even the situation is so I would say dangerous that our analysis, our office, let me put it this way. We have, during the war, we have analyzed more than 400 video and photo materials of torture and inhuman treatment. We also analyzed the speeches of Azerbaijani public authorities. The analysis revealed clear similarities. These soldiers, we have translated them from Azerbaijani into English and Russian, we uploaded them on our special database. The Azerbaijani soldiers, when torturing Armenians, mutilating them, etc., they use the same words as the political authorities use. They are being inspired by these words. And even we have special comparison, comparing the videos of torture and comparing public speeches of the president of Azerbaijan. They're literally the same. And it is very obvious that all these cases, they are not separate crimes. They are consequences of institutional state policy, which after the war has even deepened. There are lots of examples, like a vivid example is the trophy park. The trophy park and the speech of the Azerbaijani president during the opening ceremony of the trophy park, it is exactly the generation of hatred and even deepening it by presenting to the Azerbaijani nation that Armenians are the ugly part of the humanity, etc., and so forth. So I have also to say that, which is crucial, that even the highest, at the very highest level, officials follow the president of Azerbaijan, and our special reports, we have revealed even speeches or public glorification of public figures, very famous figures in this country, and the report reveals that there is even more glorification than from the side of the political authorities. So coming to the conclusion of this part, I have to say that it is like a circle. The hatred is being generated by political authorities, highly encouraged by cultural figures, very famous people, and it is like, the hatred is boiling inside the society, and the form that it went out was the war. So this is the very dangerous phenomenon for the region and globally, of course.
If you could touch, Arman, before I move on to a different subject, I wanted you to touch on a little bit about the impact you've seen of that boiling over in terms of the treatment of POWs.
Treatment of POWs, I have special reports on the treatment of POWs because we have interviewed as direct, I personally and my staff members, we have interviewed prisoners of war who were repatriated and were released and returned to Armenia. There is a systemic, even endemic torture of Armenian POWs, and not only POWs, but also civilians, so generally we can say captives. Torture, inhuman treatment, humiliation, and again, all the evidence proves that all this torture and humiliation were accompanied by the humiliating words and insulting words of the Azerbaijani armed servicemen that are identical with the political authorities' policies. And even sometimes when I read these statements, sometimes I think that human imagination, even sometimes my imagination does not afford me to understand the amount of torture and inhuman treatment. And I have to say it is systemic, and even as some international organizations call endemic, and I have to, and even moreover, after November 16 clashes, or let's say escalation, very recently, we had again new, as I said, new prisoners of war. Immediately after capturing Armenian soldiers, the social media was full of videos. We have registered already 27 photo and video materials only related to the soldiers of this one, let's say, the escalation or the attack, the part of attack, of torture, inhuman treatment, and of the same nature. If you compare, there is no difference. It's like well-organized behavior, which is highly encouraged because all these people are with open faces, openly knowing, obviously knowing that they will not get punished, and moreover, there will be only encouragement.
And Kate and Rojika, I want to start with you, Rojika, regarding avenues, alternative. We spoke a lot today about the elements of hate speech, cultural destruction, treatment of POWs, which all envelope well into the CERT case that's currently pending. But early on in the conflict, there were reports that had come out regarding Turkey's involvement in terms of mercenaries. Could you speak a little bit about what the convention regarding mercenaries implies? What are possible avenues with respect to Turkey's role in terms of bringing Syrian mercenaries into the conflict zone to join Azerbaijani forces during the war progression?
Yeah, thank you. And actually, I think this really gets at this also gets at the issue of recognition, not just of what's happening now or what happened last year, but also recognition of the Armenian genocide itself and the sort of backward-looking effects or purposes for restitution and compensation. And of course, that didn't happen with respect to the Armenian genocide of 100 years ago. Turkey does still continue to deny it. And that lack of recognition, I think, is clearly the context in which these events are occurring. And that was really the first thing that sort of alarmed us when we saw Turkey inserting itself into this conflict by hiring, paying for, equipping mercenaries who appear, apparently according to the reports, are fighters from Syria, some of whom are former ISIS. And so we really sort of had to ask ourselves, well, why is Turkey doing this? And, one, I think it raises the specter of genocide again, just by simple fact of Turkey's involvement, opposing Armenians. And especially because there hasn't been any recognition of the genocide. And then two, it has the potential, and I think it has, fanned the flames of these old hatreds and these old resentments and these old passions. So those are the things that really concerned us when we saw Turkey, by multiple accounts, hiring these mercenaries, which are really essentially, soldiers for hire, paid soldiers. The use of mercenaries is outlawed in a couple of major international conventions, one being the first additional protocol to the 4 Geneva Conventions, and then there is a specific international convention on mercenaries, which forbids the recruitment, the use, the financing, or the training of mercenaries. Azerbaijan is a party to that convention. Turkey is not. But the fact that Azerbaijan is and has accepted the use of these mercenaries, I think, clearly puts it in violation of that convention and of some customary international law with respect to the use of mercenaries. So it's very concerning.
And we're going to be opening up to Q&A very shortly. We have one other topic to really kind of encapsulate at least our initial discussion here. And Kate, I wanted to go to you with this one to start, and that is conflict resolution. What is the value of international justice processes in conflict resolution? Number one, I guess, in terms of a kind of a high-level theoretical answer. And then secondly, it's clear, even in our discussion today, that the Artsakh War was more than about territory, that there's a lot more water under this bridge. How do the international justice processes feed conflict resolution discussions? What is the role that you see for organizations such as the OSCE Minsk Group in this process? And if you don't mind me asking a third aspect of this question, what are the similarities or differences that you see between the situation, the status in terms of Artsakh and Kosovo? Maybe that last question was a lot broader than the first two, so.
I can have a go. So I think the role of international justice in conflict resolution maybe comes back to what Rajika alluded to when she was talking about transitional justice. So I think there's a general agreement now that some kind of justice mechanism, so some kind of criminal prosecutions, perhaps even, especially if those most responsible, is a valuable part of trying to move towards conflict resolution. And then ancillary to that, there may be other kinds of truth-telling processes. So some identification of the facts in a way that allows the victims to feel like they have got some kind of justice. And of course, famously, I mean, that can take different forms. Famously in South Africa, there was this Truth Commission, which was then accompanied by amnesties. And there have been attempts to set up other truth commissions, but of course, if it's not accompanied by an amnesty, the perpetrators have no incentive to tell the truth. So it tends to have to be that kind of state-organised event. But some sort of memorialisation, some surfacing of what actually happened to people, listening to the victims' accounts as well, in some forum which validates them, and prosecution of at least those who are responsible for the most heinous crimes or those most responsible, I think is pretty much understood to be a necessary part of moving forward. And I mean, no peace without justice is the slogan, right? No peace without justice, which has been challenged. There are examples of countries which seem to have been able to move to some kind of peace and don't want to dig up the past. But I think, perhaps I can just answer that more personally. When I was working at the Rwanda and the Yugoslavia tribunals, and I also worked in both Bosnia and Rwanda, so I was very familiar with, victims and survivors of both of those tragedies. I was always asking myself, like, what's this doing, this court? What's the value of it? Like, what is it contributing to? Like, exactly the question you're asking me, is this leading to reconciliation? Is it going to stop these things happening again? What's it doing? And I was never really able to answer that question, but one thing I really could hold on to was that for those victims of that particular trial who came in and who gave their evidence and who left, I really could see that this was something very, very important. And I think probably everybody in this room doesn't need to be told that. I think it's very instinctive, this need for justice when you've been wronged, when something terrible's happened, maybe to your family members. And it's a bit the expression, the feeling you were giving vent to at the beginning, like, why wasn't, well, Mr. Tatoyan was saying, we're putting out videos, why wasn't anyone doing anything? And I think the value, to respond to that with some kind of official justice mechanism is very important. It's very important for the victims themselves to be able to move on, because otherwise it's just this huge ask, like what's going on? You know, this terrible thing happened and I need that acknowledged. So I think it's very important. You asked about the role of the Minsk group. I mean, that is the body that the international community has come up with to try and shepherd this situation into some kind of resolution. So I think its potential has to be, you know, explored to the ultimate, to the utmost extent. I think probably Mr. Tatoyan has some thoughts on the potential of that and how you've seen them responding to the current situation. But I would say that obviously there has to be some kind of political solution as well. I mean, justice isn't enough. It would be very important for justice to be part of that. But it looks as though the Minsk group is the body through which those negotiations and that, you know, some kind of more final resolution of this situation would have to be sought. So very finally turning to Kosovo. I mean, Kosovo, of course, is a really interesting example because of this issue of self-determination or remedial secession. So, and by that I mean self-determination, everybody knows what that is, right? That's a right under international law for a people to determine their own fate. And the question is, when, you know, do the people of Artsakh specifically have that right? Can they exercise that right to self-determination? Do they qualify under international law? And against the idea of Artsakh perhaps splitting off and becoming its own state as opposed to joining Armenia, I suppose that's probably not really on the table, would be the idea of, you know, the other principle, which is about states basically respecting state boundaries and staying together. So those are in tension. And the idea of remedial secession would be that the right to self-determination can be exercised because of the human rights violations that people are suffering. And in Kosovo, effectively, that seemed to be, a situation similar to the situation in Artsakh, where that population was allowed to a certain extent to self-determine and to leave, you know, the FRY as it was then, or Serbia, Montenegro, and to become, well, to have the strange status it does now, but at least to have broken away from that. I think there are many parallels with the Artsakh situation. Perhaps, I don't know whether it's really a legal question or a political question. I think Kosovo had a lot of political sympathy. You know, it managed to grab the attention. It was later on in the wars in the former Yugoslavia, which had already really engaged the Security Council as well, and the international community. They were already deploying peacekeeping forces. They'd already set up the tribunal. And then, as you know, NATO even bombed Serbia for its actions in Kosovo. So was that because Kosovo was in a very different situation legally? I'm not sure that that really would be the distinction. Was it that Kosovo is in a very different situation politically? Probably. And so there maybe we come back to your question about the Minsk group and about how relevant that might be in moving forward.
There we go. Yeah, thank you, Kate. And I think it does kind of bring us back full circle. And I wanted to ask Arman to kind of close up our discussion before we open it up for Q&A with kind of looking at it through a magnifying glass and saying where we are. There's a lot of geopolitical stratagem going on right now in the South Caucasus. There's no question. Anybody who follows can see everything and all the players that are now involved in whether it's transportation, whether it's communication, whether it's roads, and clearly Arman's work has demonstrated the real human impact of that. And one thing I believe, Arman, you have spoken about, and I think it's worthwhile to kind of bring up now in closing before we go to Q&A, and that is the impact of these conditions, the state of these conditions, for example, the demarcation, delimitation of boundaries, as not allowing for human rights to be protected or to be flourished. Can you talk a little bit about that? I'm going to have you articulate it a lot better than I did, but the state of aggression that we're in, because these, unlike when we're talking in retrospect about Rwanda, about Cambodia, about Yugoslavia, we have a sense that those are done, and now we're sitting here kind of discussing it. This current situation seems to have a really ongoing flavor, and demarcation and delimitation is part of this story. And what part of it is it, Arman, and how do you see that impacting human rights of Armenians, whether they're in Artsakh or in Armenia?
Well, today we discussed certain things and related to politics, to geopolitics. So we highlighted, yes, there is certain influence, etc. What I want to say that unfortunately, human dimension here is always ignored, or in most cases is ignored, which is unacceptable. There is a political-military dimension, which, yes, we have to face it, we have to take it into account, because we cannot avoid it, it is not possible to prevent it. But instead, we have to strengthen the human dimension, because all of these processes at the end, they influence human rights, real people, human beings, people who live in these territories. And I think that then governments, well, in this case our government, must strengthen human dimension in order to strengthen the political-military dimension with the human dimension, because this is very important. And the human dimension, human rights provide huge possibilities for governments to use international mechanisms. We spoke about OSCE Minsk Group. This is a very important format, but it is more of political nature. And apart from this, we have UN structures, we have Council of Europe structures, European Union structures, etc., which could be used based on human rights human dimension. And Azerbaijani authorities have been always doing their best to ignore the human dimension and to consider everything, to bring everything under the political-military roof, and to consider from that angle. Important thing here is, or the only way for the prevention, I see the responsibility and accountability of authorities, of Azerbaijani authorities. Because the only source for all these violations, be this at the border, against POWs, etc., is the only, this is the only source for these violations. It is the policy of Armenophobia, state-sponsored policy of hatred and Armenophobia. Apart from all of this, all the perpetrators of this torture, severe torture, inhuman treatment, beheadings, etc., they remain unpunished. There is impunity. And there is a very clear principle in the jurisprudence that impunity leads to severe crimes, more crimes. And that is why punishment is here important. Even so, having said all of this, let me also say that I think hatred and the policy of sponsoring hatred, encouraging Armenophobia, is also dangerous for other countries, not only for Armenia, because this policy is intentionally keeping atmosphere of animosity between the two people in the whole world. Armenians and Azerbaijanis live together in many countries, United States of America, France, Russia, and it is a very easy tool also to play with the stability of these countries with human rights mechanisms, etc. And we had, by the way, there was, I had chance myself with support of ANCA and together with one of our prominent lawyers, Mr. Karol Azarian, we went to San Francisco to the church that was set on fire, to the school that was, Armenian school that was vandalized during the war. And these are consequences of these policies. That is why the world has to recognize that impunity may lead to problems worldwide to the nationals or citizens living in these countries, which is also very important to take into account. Now, when it comes to delimitation and demarcation, Unfortunately, this process is being carried out through gross violation of international standards. According to, there are certain international standards, OSCE standards, UN standards, according to which demarcation and delimitation, so in other words saying border determination process, must be carried out peacefully, with respect of human rights, rule of law, and democracy. There are certain indicating questions that as a result, that their delimitation and demarcation should not affect normal life and traditions even of the local population, of border population. This is number one indicator that legitimizes or delegitimizes the whole process. What we have in Armenia right now, normal life of border population, traditions even, it's just the only thing is that normal life, security and peace of people is totally disrupted, is destroyed. Human rights are violated, and they remain violated. Our fact-finding missions, we launched immediately after the war, fact-finding, and we visited all bordering areas of Armenia, all civilian communities. And I have to say that in all these places, we have continuous violation. Azerbaijani armed forces are physically present in the lands that belong by legal documentation to Armenian civilians. Even these documentations were issued by Soviet Armenian authorities. Azerbaijanis are present there. We experience shootings almost every day. They're targeting civilians. They're targeting civilian houses. We have cases when a child is playing in the yard and the shooting is directed towards that house. We have cases of gross violation of the right to freedom of movement. On the roads in the Sunnik province of Armenia, Azerbaijanis are present, armed servicemen are present on certain sections of the road, claiming as if these are Azerbaijanis. Azerbaijan belongs to Azerbaijan, this territory. But because of their presence, people are deprived of the right to free movement. They try to avoid using these roads to the security issues. And moreover, on the certain parts of this road, Azerbaijani so-called checkpoints, customs and border control checkpoints were installed very recently, which blocked movement of people at all, and put all the neighboring villages in a humanitarian crisis situation. Apparently, the Azerbaijani armed forces appeared in the direct vicinity of Armenian villages and on the roads as a result of genocidal policy and as a result of political-military dimension, political-military processes. So what we have now, human dimension is totally ignored, and the normal life of people is totally disrupted. That is why I think we have always to go to keep these factors together. We can, because this is international standard. There is a clear OSCE guidebook, clear UN guidebook, providing that any determination of borders must be based on respect for human rights and peace and security of people, which unfortunately is completely violated in our case.
Arman, thank you, and I would like to thank our panelists as well, Kate and Rajika, for joining us in this conversation today. Clearly, the role of international legal structures, whether it involves demarcation, as Arman just spoke of, or human rights, whether it's CERD or mercenaries, or whether it's the procedural aspect, the creation of tribunals and such, play an important role in making sense of and gaining insights to what is clearly a still living situation for Armenia and Armenians. And with that, I want to call Alex Galitsky back up to the podium so that we can open up the floor for some questions for our panelists. Alex, are we handing out cards? Or no? Okay. If anybody has a question for our panelists, please do raise your hand. Do you want me just to take them, Alex? Yep. Sure. Sir?
thank you all for engaging in the formal discussion. I certainly learned a lot more about the subtle ways in which the international organizations play a role, some of the subtleties in that role. But I have a couple of questions, particularly in the context of this parity, which seems to immobilize, and one may argue paralyze, these organizations. What does the concept of self-defense play a role? How does self-defense play a role in this parity, where one talks about how do you justify the concept of parity when you talk about persecuted people or attacked people who then try to self-defend their dignity, their lives, their communities, they do actions, and now you hold that in parity to the aggressive actions which are documented there. And the related question, then what does it say about these organizations that are supposed to act through these events, where specifically I'm looking at you, Ms. McIntosh and Ms. Sharp, when you talk about the tribunals of Bosnia, Rwanda, where it took decades to, I might argue, somewhat ineffectively to prosecute those events over decades. And yet we have every year seems like there's another such aggression happening somewhere around the world, and there seems to be no remedy from international organizations to even stem the tide, let alone stop it.
Would you like to take that first? Yeah.
Sure. So on the self-defense point, what I would say is in international law, that is actually the only permissible use of force under the UN Charter framework is action in self-defense. And the action, Kate, you can correct me if I get this wrong, but it should always, whether it is offensive or defensive, it should always be subject to basic principles of necessity and proportionality. So as in a domestic self-defense situation internationally, when a state undertakes its own self-defense, the goal is merely to meet the action and stem it, not to sort of raise the bar, so to speak, or engage in retaliatory or punitive actions. So with respect to the parity question, I guess what I would say is the fundamental norms of international humanitarian law, international human rights law, law of armed conflict, those apply to any party to the conflict. And so the question of whether the use of force is lawful is a separate one from whether the force, what's the phrase I'm trying to, there are these Latin phrases that are used, the lawfulness of the use of force versus the sort of means and methods of the warfare itself. And so I think that those two things are considered separately. So that is, I guess, one response that I have on the question of parity and self-defense. With respect to your second point, stemming the tide, why is it that we continue to have these serious mass atrocity situations and conflicts happening over and over? Why aren't they being stopped? I think that was one of the original, maybe the primary motivating factor behind the establishment of the International Criminal Court, was for the international community to try to set up some kind of standing permanent body to prosecute those individuals who are accused of serious atrocity crimes, and also for the deterrence factor. Unfortunately, as I think Kate mentioned previously, international law is very much based around the idea of sovereignty and consent. And because sovereignty really sits at the heart of international law, no state is obligated to sign up to the ICC. States are free to choose not to become parties to that statute or to that court. And there really is no mechanism in international law to say that they can't. So again, that takes us back to the politics of it. The Security Council can refer situations to the ICC, even with respect to actions relating to a state that's not a party, but then you have to deal with the politics.
Thank you, Rashida. We have another question.
Sure. I can speak loudly. My name is Arman. Thank you for this opportunity to learn from you guys. Mr. Tatoyan, I was so moved by your comments that you've been hearing against the diaspora abroad. And it's very amusing and funny, and I've kind of heard that myself. And ANCA has kind of been the butt of those jokes. And if ANCA would just stay out of Armenia's business, everything would be fine. So I actually came with a prepared question, which fits into that. In your opinion, what is the responsibility, not it would be nice, but just responsibility of the Armenian diaspora in helping Armenian or Armenians in Armenian Artsakh? And I don't mean specifically doctors who can go provide care, or attorneys who can take up cases, or businessmen who can be entrepreneurs and create jobs and start companies in Armenia. I'm referring to the responsibility of a very average citizen who makes an average living, is raising kids, and he doesn't speak English very well. Thank you so much.
Thank you. Well, maybe not responsibility in this case, but the role of diaspora. I think it goes beyond any discussion that unity and solidarity is needed more than ever now between diaspora, Armenia and Artsakh. What I would do, I would invite our compatriots to visit Armenia more than ever, to be with Armenia, but of course we also have to be with the diaspora. But now in case of diaspora, I also want to deliver a message that when visiting Armenia, we have to know that Armenia is not only Yerevan. The real Armenia is, these are marzes, these are regions of our country, where people live their daily life, their livestock there, etc. And in order to understand the essence of our country, to understand the real problems, the real issues, I think this is the way that every, or the real, or average citizen, as you said, could bring their help to visit, to be with people, to understand what are the real issues. And then, based on the activity, on the role of a person, I don't know, different factors, could start the assistance maybe, or continue their assistance, or deepen, or even change, because what we had before the war and what we have now, these are two different worlds. And that is why I'm saying that real Armenia now, given the tensions, given the problems, is not only Yerevan. You may come to Yerevan, you may see there some happy people sitting in cafes, but this is not real Armenia. And this would be my message, let's say. And of course, I think even assistance or joint co-work and coexistence and cooperation between Armenia diaspora and Artsakh is more than ever important. The situation itself brings us, I think, to this one very clear conclusion.
Thank you very much, Arman. And I'd like to call Alex back up here to wrap up our panel. And while he's walking up, thank the panelists very much again for really helping us identify some difficult subjects, some difficult issues at a very critical moment in Armenian history. In fact, I feel that we're often, unfortunately, back at the moment where we are in a critical moment in our history. And we are living that history, and I thank you, each of you, for spending time with us today in really digging in on some of the legal issues and the justice issues and, of course, the human rights issues that are enveloped into our present reality. Thank you. Alex?
I'm sorry that we can't continue with the questions, but we are out of time right now. But thank you all for attending. On behalf of the ANCA Western Region, I'd like to extend our deepest gratitude to our co-hosts, the UCLA Promise Armenian Institute, the UCLA Promise Human Rights Institute, and the CSUN Armenian Studies Department. And of course, our esteemed panelists, Rajika Shah, Kate McIntosh, Dr. Arman Tatoyan, and our facilitator, Karnik Kerkonyan. Thank you so much for participating in our 2021 Grassroots Conference. In these trying times for the Armenian nation, we're immensely grateful for your contribution to shedding light on these important legal questions and, of course, the injustices inflicted against our people in this pursuit for accountability. I think I can say safely on behalf of everyone here that it's thanks to you that we remain hopeful that the perpetrators of these egregious crimes against the Armenian people will be brought to justice. To conclude tonight's discussion, I'd like to invite the Interim Executive Director of the ANCA Western Region to present a small token of appreciation to our panelists, as well as to Dr. Varam Shemasyan for hosting us here as part of the CSUN Armenian Studies Department, and student Seropyan for all his assistance in helping organize tonight's incredible discussion. Thank you very much, everyone, and good night. Thank you, everyone, and we wish you all the best for the holiday season, and please stay safe.
Thank you.